Hi, everybody. My name is Ryan Black. I'm a partner at DLA Piper Canada in Vancouver. And we're here today for a panel of Ask Lawyers Anything. This normally would cost a lot of money. We're not going to disclose our billable rates on this call when we were all private practice lawyers. I did want to start off, though, just on a little bit more of a serious note. For lawyers, the last 24 hours have been pretty impactful, and we wanted to, we all decided there was someone on our panel who wanted to say a few words. And we think this is a great idea. So I'm going to turn it over to Brandon to get started, and I'll ask Christina to put up the slide.
Yeah, thanks, Ryan. So yesterday we lost Ruth Bader Ginsburg, Justice Ruth Bader Ginsburg, which is a huge loss for the legal profession and for the country as a whole. We lost a great legal mind, a stalwart advocate for equality in the country and in the world. She really was the embodiment of justice before her title was Associate Justice, and then continued that legacy on the court. And she fought her entire life for the profession, for justice and equality. And we're going to try to continue her legacy and do that as we move forward. We're hopeful that she's able to find some rest now. And to honor her strength in life, and often a quiet strength, we thought it would be appropriate to do a brief moment of silence. So with that, I'll go on mute and we'll take a brief moment here.
Thanks very much, Brandon, and thanks, everybody. We're going to get started with a regular panel. We'll do our best to be non-dour and bring it back up the mood a little bit here. The point is to connect lawyers with people in a way that hopefully resonates with people. So I'd like to start by introducing the lawyers on the panel. So if we can go back to the six of our lovely faces here. Christina, we'll ask people to introduce themselves. I've already introduced myself. I practice mostly in technology and video game law. I'm going to go next with Yen.
Hi everyone, my name is Yen Kern. I'm the Associate General Counsel for a developer and publisher called NCSoft. I'm super excited to be here. Before that, I was working at a firm doing kind of more general M&A, business, IP, some employment, a lot of esports. And so, if anyone has any questions, please feel free to put in the Discord, and I'm sure this team will, try to address as many questions as we can.
Thanks very much, Yen. Next up is Matt.
Hi, everyone. My name is Matt Doble. I am an associate attorney at Frankfurt, Krennet, Klein & Sells, a law firm in New York and Los Angeles. I practice pretty much exclusively video game law. All of my clients are developers and publishers and content creators in the video game space. And before that, I had a stint at Activision working on your Call of Duties, your Crash Bandicoots, and your Sekiros. So really excited for everyone's questions.
Thanks so much, Matt. We're going to now go on to Jeannie Doi.
Hi, my name is Jeannie. I'm an immigration lawyer with ESG Law, the world's first esports dedicated law firm. We work mostly with teams and organizations as well as broadcast talent. So if you guys have visa questions, questions about international travel, I am your go-to person.
Excellent. We're going to bring it over to Raleigh, North Carolina with Mr. Brandon J. Huffman.
Hi, I'm Brandon. I'm an attorney. I have a law firm called Odin Law and Media. We are, like Matt, focused in the video game vertical and some ancillary things alongside that. We focus mostly on corporate and intellectual property issues and industry contracts. And beyond that, I'm also the general counsel for the International Game Developers Association.
Next up, we've got Angelo, and I think, Angelo, if I'm not mistaken, you're probably the first person I ever did one of these AMAs with. But
yeah, I think you're right. Yeah, we go way back. My name is Angelo Alcid. I'm an attorney located in near San Francisco, California. I help developers, content creators with IP issues, privacy, technology transactions, licensing, that sort of thing. Full disclosure, I also have a day job at a technology company that rhymes with a cute race of Final Fantasy creatures. I won't be speaking on behalf of that company. I'll be speaking just on my own behalf as an attorney.
Awesome. Okay, so Christina, we're going to put back up the slides here for a second because I'm going to put up what lawyers do best, which is a big giant disclaimer. And the disclaimer is just simply this: we're not your lawyers. This is for information purposes only. Nothing we say is legal advice. You should contact your own lawyer for legal advice, and please pay her for her work. Nothing we say creates any legal lawyer and client privilege. If you have a specific situation in mind, we just ask that you use hypotheticals because we're going to avoid talking about specific cases. Last, as Brandon alluded to, and this is true for all of us, our statements and opinions are our own and not of our firms, companies, clients, outside organizations, or employers. And so with that, well, I should say other than Brandon, who is his own employer, but well, we'll leave it at that. Okay, so I'm going to quickly run through. So what we're going to do while we give some folks a chance to ask questions in the room, don't worry, we're assembling them. We're assembling the questions to answer. What we're going to do is we've assembled kind of just our thoughts on all sorts of experiential things we've done over time. And we're going to run through a very quick top 10 list of issues that we commonly run into. And these are theme-based issues. These are experience-based issues. Experience is everything in law. And this is why you can't like smart yourself into a good contract. You have to kind of know people who know what they're doing. A problem may be unique to you, but it's not going to be that unique to lawyers. I think, you know, the number of times that someone comes to Jeannie or Angelo or even in-house with Yen and so, you know, people come to you saying, oh, we've got this problem, the world's coming down, and lawyers are like, yeah, we've seen it before, we'll deal with it. So experience is everything. So top 10 tips for experience real quick. I'm going to break at the 5 and 10 points so that my panel can get in here with their thoughts. The first one is there's no one size all fit for a contract. There's no precedent that's good for all contracts and all situations. Don't copy and paste something, even if it's from a really good looking precedent, without really understanding what it says. Read it and also read some alternatives if you're going to be quick and dirty about it. Tip 2, when you hire someone, you're always involving the laws of the place where they live. It is impossible to hire a worker under local law and have them work somewhere else. They're going to be working under their law. And so you might have tax problems, employment law problems, a whole bunch of things like that. Don't just assume that because you're hiring someone that you know how that works. And this applies across state borders, and this applies across country borders. Generally speaking, check your network for other people who've hired folks. You'll usually run into a few horror stories if you ask your colleagues, hey, did you ever hire someone from France? And they'll say, yeah, we hired someone from France. By the way, you can't really fire them, so be careful, right? So anyway, we'll move on to the next one. 3, please be clear and active in your contracts about who owns the IP to the things that are being developed. Don't just assume that because you pay for something that you're going to own that thing. Deal with ownership up front before the game is successful and not at the end after the game is successful. Question 4, please deal with difficult issues as soon as you can and don't wait for a deadline or the issue to become critical. I can tell you from experience, the worst time to negotiate a really difficult issue is when there's a really critical deal on the table or there's a really important decision to be made. That's the worst time to evaluate how to deal with a problem. Don't rely on the existence of some, you know, technicality that's going to get you off. Don't hide problems. Talk to your legal counsel about it and spend time actually identifying what your key issues are. And then the 5th quick tip, even without a lawyer, please keep written records of all your agreements. Anything in writing is better than nothing in writing, in my view. If you do your best to write down at the time what it is you intend to do, you're actually going to end up probably having a chance of doing that and being supported by it. Don't just rely on your memory. You're going to be surprised what you forget. I'd like to throw it back to the room, Christina, if we could, to show everyone's faces and let folks talk about any of those tips that they had for the rest of the panel. So I see Jeannie, you're unmuted. Go ahead.
Yeah, so going back to the point about hiring someone in your jurisdiction, so maybe close to where you live, the one exception is with federal law. So when you come across law like that's federal, for example, immigration or bankruptcy, those laws are the same in all 50 states. So even if you live in New York, you can hire an immigration lawyer who lives and works in California because the law that they practice is all the same. So those are the two exceptions. If you're looking for a good bankruptcy lawyer or a good immigration lawyer, you're not limited to your jurisdiction or your state.
Perfect. Thanks so much, Jeannie. And Yan?
I wanted to jump in a little bit about kind of the number one, no one size fits all contract. And it's not just contract, let's say, an employment contract or any other types of contracts, but really think about kind of your privacy policy and your, user agreement, different other policies like their moderation policy. And, it's easy to say, hey, there's this big tech company who's already spent, the time and brain power on this. Let's just use theirs. But so many of these contracts are very specific to the exact type of data that you collect, the exact type of relationship that you have with your customers. So, kind of read contracts broadly to like all contracts between you and kind of your customers or clients. The other one I wanted to touch a little bit briefly on too is number 3 and 4, kind of, dealing with IP rights, face difficult issues head on. I've seen so many friendships actually saved because the two friends were very clear from the beginning, who owns this, what happens if things go poorly, what happens if things go well, having all those conversations and really truly understanding what the deal is from the start actually saves friendships, because when things happen, you say, oh, great, we've already thought about this, especially during like, that really great time when everyone's building something, as opposed to when there's a difficult situation, when there's a deadline, it's high stress, you have little time to figure out. And then, not only is it kind of great on that friendship, personal level, but it also saves you so much more money. By the time something happens, it takes way more money, way more legal fees to try to fix and undo things. So having kind of all of that up front, especially let's say, later on, if you're trying to sell the company or trying to get investors, cleaning it up afterwards just causes more problems for you. So, don't hesitate to face those issues hard on, or, reach out to attorneys early on.
For sure. Angelo?
I actually have a similar point. I want to add to that. Reach out, get a lawyer or lawyers, I guess, involved early in the process, because it's so much easier to deal with things like, let's do a trademark search on your name to make sure it's not going to cause a conflict later. Conveniently, Ubisoft just ran into this issue this past week so that I could talk about it on this panel. This is the exact thing I advise people to try to avoid down the line by doing a trademark search or something early on, to make sure the name of your game or your branding for your stream or anything is clear, so that you don't have to build an audience, build up hype, and then have to change it down the line. Ubisoft just changed the name of their game, Gods and Monsters, to Immortals Phoenix Rising, because their trademark application was challenged by a Monster energy drink. And so that's probably a bunch of marketing money down the drain that they have to redo now. So that's definitely the kind of thing you want to avoid. But address these issues early.
You're right. Thanks so much, Angelo, and great points, everyone. And I think we can all agree that's absolutely the worst thing that happened to Ubisoft this year. Nothing else terrible or controversial has happened to them. Okay, so we're going to move on. Thanks very much for putting questions in the room. We've got some building up. I'm going to move on back to the slides to tip number 6, which is there's no such thing as the wild, wild west where law doesn't apply. Don't just assume that because you're doing something that you think that no one else has done, that old laws don't apply to you. Law always applies to you. It's probably the wrong law that was never intended to apply to you, but it does. We see this in esports, we see this in loot boxes, we see this in a whole bunch of different areas where old laws are constantly creating problems for new technologies. So if others do something that doesn't make it legal, and also just think for a little bit, why haven't our competitors done this before? Like why don't we just have a restaurant, or why can't we just sell buildings that are cheaper because they don't have fire escapes? Well, it's because there's a law that says you have to have fire escapes. You can't just innovate your way out of that. So 7, IP rights protect almost everything you see, access, or use. So please don't assume that just because you can see, touch, find it, or search it on Google that you can use it or copy it. Please don't try your best not to base your stuff off of other people's work unless you understand the rights involved with doing so. The default of something that you see is not, I can do whatever I like with it. It's not that they have to put a statement on it to say you can't. It's the opposite. You need to know what you can do with it. 8, always be truthful when you're dealing with the public or with the government. And even, what we mean by that is avoid false or misleading inferences. Don't assume that small print is going to save you from a false or misleading inference. Small print is not going to do that. The overall, ultimately, it's the overall thing that matters more than anything else. So please be deferential. Please be clear when you're making representations. Number 9, none of us are tax lawyers on this thing, but we're all smart enough to know that tax is probably the #1 driver of most business activity. And tax always matters. Don't assume that you can do anything or any business activity without paying the piper somehow. The government always wants their piece. So please plan ahead for taxable events. You can't move IP, you can't move people, you can't open offices, you can't do a whole bunch of things without considering the tax consequences. Last, please consult professional advice. Don't assume that you can't afford to speak to a professional. In fact, you can afford to speak to a professional. You might not be able to hire them, but you can absolutely speak to them. Even sounding out or writing down problems that you're facing may help you actually solve that problem or turn it into something manageable. Also, professionals want your business. They're generally, I don't know, Brandon and I can maybe talk a little bit about it if the question arises in the room, but we'll generally sit down with folks if they have a question and give them a lay of the land before they have to hire us or pay us any money. I think this is true of most lawyers, most accountants. You need good accounting advice, you need good lawyer advice, you need good immigration advice, you need a whole bunch of things that you should really talk to someone before you decide you can't afford them. So I'm going to now open it up to the room again for my fellow participants to see if anyone has anything they would like to add on the 5 things that we've done there. I'm not seeing any unmuted folks, so I think that means that we're ready to go into the questions because we do have a bunch. So I'm not sure if the slide's up right now, Christina, or if it's me. So I've got a slide of suggested questions. Take a quick look at them. Feel free to think of ideas from there, but we're actually going to go to the room's questions. So I think we should flip it back to the camera with all 6 of us, and we'll go from there. Awesome. Okay. So the first question I saw in the room was, what do game lawyers normally do? And I thought it would be really interesting to take that from an in-house and an external perspective. So I'm going to start with Yen and then go to Matt.
Sorry, the question is, what do game lawyers do?
Yeah.
Ooh, so lots of meetings. So I guess, I think for in-house, you have kind of all the other issues that every company has. So we have to deal with immigration, we have to deal with employment, we have to deal with, just general contracts like vendors. We have to deal with tax. So in the in-house situation, basically it's anything that any business kind of has to deal with. Plus, I think there's that really strong software, intellectual property, art kind of component. And so depending on if you're a studio that develops games, then you're much more heavy on kind of engineering, art, audio, getting things into the game. And then if you're also a publisher, then there's a lot more kind of contracts with, let's say, Xbox, Epic, Steam, all the distributors, and then also with the publishers and developers. So it's a lot of contract work, always with kind of this facet of intellectual property. So I guess that's kind of in a nutshell. In an in-house, it's basically you're a generalist with a lot of resources that you can tap in whenever there's a specific issue that comes up.
All right, I can hop in. So the very interesting difference that a lot of people don't realize between in-house attorneys and firm attorneys is when you're an in-house attorney, you have one client, and your client is the company that you work for. And so when you're an in-house attorney, your job is to provide a service for the business, which is protect the business, keep the well-oiled machine that gets the games out there and the fun stuff happening out there and happening. But when you are at a firm, your job is a little bit more to kind of serve as an outside service to the business, perhaps in ways that in-house counsel may not be able to. So a lot of my clients are video game companies where they may not have a lawyer, and so they come to my law firm and use me kind of as a resource or as outsourced legal counsel. But a large amount of the work that I do at a firm is actually for lawyers at video game companies. So a lot of people don't realize that for working in kind of a multinational video game company, like NCSoft is a wonderful example, you have to think about legal issues that happen in every single jurisdiction in the world. And so usually that means having a lawyer like Ryan in Canada, or like me or Brandon or Angelo or Jeannie in the United States that can navigate the law in that particular jurisdiction. So while we do contracts, there are compliance issues, there are kind of all sorts of novel law issues that an in-house legal team may go to an outside lawyer and say, look, I get 90% of this, but 10% of this is new, and I want to know specifically what's going on with this.
Thanks so much. Generally speaking, yeah, it's quite a cornucopia of activities. There's no shortage of things to do when you're a games lawyer. The next question we have is just a cheeky one, so I'm just going to quickly take it, which is, can I get CLE credits for this panel? That is between you and your bar association, my friend. In Canada, you certainly could, so I don't know what to tell you about that. Okay, so here's a question. How well do judges really grok or understand, for the non-nerds, the legal issues facing video games and technology that are outside of traditional business, finance, copyright, etc.? In other words, how well do we think judges actually understand the complex and evolving areas of business law? And I've got folks who are ready to talk about this. I'm going to start with Brandon.
Yeah, so I think judges are like any other people, right? They are human beings. And I think it really, really depends on the judge you get. If you are litigating that kind of issue, you want to have an experienced litigation attorney in that jurisdiction that knows the judges in that jurisdiction, so they can maybe, as much as possible, we're not supposed to use the word, but judge shop a little bit. You're not supposed to say that because the courts don't like that. But yeah, if you can get your case in front of a judge that is going to understand those issues, it's probably better for you. Unless you're in the wrong, and then it might be better to have a judge that doesn't. So you definitely want a litigator who can make that part of the strategy.
All right, Matt.
The other thing to consider too is, like, when a lot of people think of a judge, they think of kind of like a singular person. So if you have a case, it's going before kind of like this one usually older person who is like sitting on a bench that you think does not understand the law. The reality of the fact is judges have an entire staff of attorneys underneath them called clerks. And clerks sometimes are fresh out of law school. Sometimes they've been working for the judge for years. And some of the most compelling decisions that come out of video game law usually involve a clerk who's working on a judge's staff who's like, man, I play that game and I play it every single day. So this like Fortnite lawsuit that's in front of me, my kid plays Fortnite every day. I totally know this. Judge, I got this. And so there's someone behind the scenes explaining how the game works, knowing how the game works. And it's not just kind of like this one pillar of a person who's completely out of touch with technology.
Well, and even if it is, an effective litigation strategy should involve telling the story in a way that makes the judge understand it, even if they don't understand it. So if you get good representation, it shouldn't matter if the judge doesn't understand it going in.
Impressive litigators are crazy impressive. Like when you see it, you know it, and it's insane. Yen, and then Jeannie.
Yeah, just to add on to that a little bit, I think, kind of Ryan mentioned in one of his slides, there's really no such thing as the true wild, wild west. I mean, these judges, they know the law very specifically, maybe in other industries that they've applied it to. And so a lot of the strategy is making sure kind of, I don't want to say dumb it down, but in effect, kind of speaking their language so that they can truly understand, why does this law apply in this case? What are the similarities? And really making that analogy for them. And I agree. I mean, depending on the judge, I mean, I've externed for a judge too, and we brought in specialists to say, okay, this, semiconductors, we know nothing about that. What does this truly mean? How does the technology work? And so I think if you're able to have that compelling story to really tell that story, then the clerks and the experts, I think, will help explain that to the judge.
Absolutely. So I don't deal with judges who wear the robes and sit on panels on a daily basis, but I work with adjudicators, officers who review immigration applications, and they're making a judgment of this person's credentials based on the law. And the majority of immigration officers are actually law enforcement retirees. So they're pretty much boomers. They don't have a lot of knowledge about video games. They have a lot of knowledge about traditional sports. And so a lot of times I'll make analogies between like CSGO to the NBA or the LCS to the NFL. So as Yen said, there's a lot of like hand-holding and teaching and telling a story in a way that this officer, this judge, who's not part of the world, not part of the community, is going to understand and judge favorably.
Super interesting. I have no litigation bone anywhere in my body, so talking to judges, I've done it once in my life to plead to a lesser included charge on a speeding ticket, and that's about it. Okay, so I am going to move on to the next question, which I have to admit I'm going to do my best to understand. I'll ask the room if they have any thoughts on it, but it's for the lawyers. When using music generation software, what should you look for in the usage licensing, even if you're generating original work with tool provided assets? So my first thought was you might be using samples in there that may not be permitted for for royalty bearing uses or commercial uses. And I want to open up the room. I see Angelo and then Matt.
Yeah, definitely take a look at what you can and can't do with that license. There might be some requirements about like attribution or that sort of thing. But I was actually a related question that wasn't asked is if you're gonna use this sort of music generation software, be careful for those samples when you upload to platforms like YouTube or Twitch. If they have any copyrighted material in just the samples, even if you've created an original work, an automated algorithm might still catch that, and you might still get flagged for something, even though down the line that's something you can contest. It's been a big problem for creators using tools like this. I know the platforms are working on trying to weed this out, but it's just going to be a headache that you might have to deal with if you're going to use software like that.
Yeah, and in addition to looking at kind of like the rights in whatever stems or samples that you're using, the other thing that I think is a little bit less of an issue is making sure that the software itself can be used for whatever purpose you're using it for. So a really good example is in video game end user license agreements, there's usually some sort of language that says you can use it for your own personal entertainment, non-commercial purposes. And in music generation software, typically there's not going to be a restriction on using something for non-commercial use, because music generation inherently is to be used for something. But it's definitely something to take a look at too, because most people think the music's clear, I'm good to go, but there is kind of more variables to look at, always more variables to look at.
Yeah, usually, I know a EULA can be so long. If, when I take a look, the key provisions I always jump to first is the license grant. So what rights do I actually have? And then kind of, as Angela and Matt mentioned, sometimes there's a restriction part, attribution part, and then typically sometimes there's also this user generation or IP ownership. And I think read it carefully, because especially with these type of softwares, if there are stems, there's other licensors, and so the software itself only has certain rights from the music owners that they can actually grant to you. So take a look at those kind of provisions carefully, and obviously, read the whole thing as well, because you just never know what might be in different sections.
Yeah, and I always think when you're basing a work off of someone else's work, you better make sure they have a perpetual license to whatever it is they're granting you, because if they can pull out the sample from your song, you don't have a song anymore. So anyway, okay, so the next question we have is an interesting one that I think for the externals, and I'm betting Yen, maybe you've even dealt with this, but for historical games, they're using examples like Medal of Honor and Call of Duty. What legal issues might arise when basing them on real events or real people? And I think we should probably distinguish in this question when answering it between really, really historical events and historical events where there may still be an estate or people involved. So, Brandon.
Yeah, so whenever you're dealing with something that involves real people, you have privacy and by extension publicity issues. Publicity rights and privacy rights vary from state to state and country to country. But if you're dealing with real people, you run the risk that you alienate those real people. So that's most important, as Ryan said, when those people are alive and can get upset about it. We've seen examples of that from Lindsay Lohan, the Fortnite dances, that sort of lawsuit that has come about. But even if you look at historical things, like the question was, we saw the Red Dead Redemption lawsuit with the Pinkertons. The Pinkerton agency is a real thing. It was a couple of people in the Old West that started an agency to do detective work and mercenary work, basically. And that's how they're depicted in the game. Today, it's a detective agency that doesn't really do the sort of Wild West mercenary stuff anymore. And they didn't really like that depiction. So they brought a lawsuit. So there's still very real concerns. If you're talking about ancient history, concerns are pretty much zero. But if you're talking about even relatively recent history, you want to make sure that you're doing your due diligence on those assets and those people.
Yep, Jeannie?
Actually have a question for Brandon. So like, let's say it's recent history, I don't know, 50s, 60s, and the person is dead, and you came out with a game or a story and portrayed this historical figure as the absolute worst. Could their estate, could their decedents come after you?
Yes. Short answer, yes. It depends on the state for how long and what rights they have, but yes, short answer.
It's interesting because in Canada, we generally think of defamation as only being an action for living folks, but it's just bizarre. The reality is, again, the more original you can be in your work, the least of these issues you have to worry about. I understand the draw of attaching to something real or attaching to a true event or a true person, but fictionalize it if you can. Fictionalize it wherever you can, if you can, is the cheapest answer before you start having to pay a lot of lawyers to answer these questions for you. The next question I have, and I think we definitely, oh, sorry, Matt, you actually wanted to say something. No, we're good?
No, we can keep going. We've got a relentless deluge of questions. Let's get through it.
All right. Next question I have is, are there any glaring downsides? And I know certainly we've had past panelists on this panel who would certainly have had an opinion on this, but are there any downsides to using a service like LegalZoom when it comes to setting up an LLC around content creation, YouTube streaming, etc.? I will say that in Canada, the amount that it costs to pay like one of these service providers and the amount that it costs to pay a lawyer does not justify not paying a lawyer to help you incorporate your company. But I'll open it up to the room, and I see Angelo first reacted with horror and then wants to speak. So
yeah, just don't do it, man. Just no. The downside is that you're paying this company a bunch of money for something that, like Ryan said, you can either pay a lawyer just a little bit more and know that a lawyer that you know and trust and can talk to actually did it, or frankly, a lot of times they're collecting fees for things that you could spend, 30 minutes researching on your favorite search engine, and do it yourself. Like most people can do enough research to be able to do something like file an LLC in their state in the US themselves. And you don't need to pay LegalZoom however many hundreds of dollars to do that. So that's, yeah, definitely either it falls into the two categories of like, you can do it yourself, save some money, or just pay a little bit more and pay an actual lawyer.
yeah, the man in the Discord says, do it right the first time instead of paying for it forever. Matt, go ahead.
The other thing too is people like the allure of LegalZoom is paying one time for something to be done and thinking that it's taken care of. The one thing that is like beneficial to incorporating your company is it gives you a liability shield from things. So if bad things happen, your company can kind of step in and take the bullet for you. If your company is not set up correctly and there is a lawsuit, oftentimes in the United States, courts will reach beyond your company to you as a person. So the biggest benefit of you having a company, which is that it can kind of step up and take the bullet for you, if it's set up incorrectly, then it can't perform that function. So, and a lawyer is going to be able to tell you, look, every year you need to pay this fee. Every year you need to make sure you submit this filing. And even those two sentences sometimes are above and beyond what LegalZoom or a platform can do, where you log in, forget your login, change your email address, and miss the email from them. A lawyer is going to hunt you down because they don't want you going after them and saying, hey, you messed up my company. It's a lot different. And seriously, like the extra heartache is so not worth it.
All right, I'm just going to do a quick time check. I want to make sure we have the full hour, Christina. I just want to make sure. Maybe she might be, our room operator might be busy. It's all right. I'm going to move on to the next question, which is actually related to our list of questions, but it's about using unoriginal IP. But anyway, I'm looking to reboot an old game from the 80s. And it's not the, I want to just do it. It's the, where would one go to research who might still have the rights or which company still holds the rights? That's actually a really tough question, and we get asked this all the time. The reality is you either know people or you don't, and I think lawyers would be a good place to start to find people who might know. The trademark database, to me, would be the first place I would look, but I see that Matt and Angelo and maybe Brandon have something to say.
Angelo, go ahead.
Oh, yeah, no. First of all, I just wanted to say thank you for actually asking this question. So many people just barrel on ahead like to make the game without even asking. But yeah, I would check to see if you know a lawyer, and you know a few in this room right now. Check that network to see if they know anyone. See if any copyrights or trademarks have been filed. If that's that's accessible through a search online, it's pretty easy. Yeah, no, frankly, I just wanted to say thank you for actually caring about this.
So, and I can jump in and speak about like how this works, good, bad, and ugly. When you're getting rights to a game, usually you will do what's called diligence, where you go through and you try, once you find that person, once you find that kind of trademark holder, or you think you have a good starting point, you will go through and try to find all of the contracts that are related to the game so you can trace all of the rights back as far as you possibly can. And when you're doing that, you, first of all, kind of have this as receipts to prove to you that you have all of the rights to the content to make the game. And then as you go forward and license all of these rights from the parties that hold them, a good lawyer will kind of add a belt and suspenders to the license agreement saying, okay, you promise me that you have all of these rights. And if you don't, and someone sues me, then you are going to pay for that lawsuit because you're promising me that you have all of these rights. And that concept is kind of called indemnification. And the crazy thing about it is it seems very straightforward and it seems very nice and comforting. Like, you're promising me these rights, and if you don't have it and a lawsuit happens, I will pay you. For any lawyer here who has been involved in an indemnification scenario, while it does sound wonderful, it is something that in practice, when it becomes time to indemnify someone, it is one of the most stressful and awful things ever. So it really is something where if you can chase those rights down and know with certainty that all of those rights are given to you, which it's very difficult to do, then pursue it. But rebooting old IP comes with that as an inherent risk. A really good example of that recently, the Gearbox lawsuit for Duke Nukem, I think forever, Duke Nukem 3D, whatever the most recent one is, the new developer had signed a contract saying that they had kind of all the rights to the game, including music. And the composer came forward and said, you actually don't have the rights to the music. And so there's a lawsuit unfolding right now about, well, what happens with the music? Who is going to pay? What is going on? And it can really take the wind out of the sails of a developer that's just trying to reboot an IP that could be on the hook now for this crazy legal bill for rights they didn't have.
Yeah, 100%. I think the unknown of an old IP is actually one of the tougher things for lawyers to get their clients' head around, because I've worked on old IPs where, you go to a really reputable licensor, you're thinking one of the big three producers, and they don't know who owns the IP to some of their stuff because it's just so historical. There's been so many sub-licenses and exclusivity grants and grant backs and authors' rights things and all that sort of stuff. So next question we have in the queue is, how do all the Candy Crush and Tetris style games not breach copyright? This is actually an interesting area of law that lawyers speak themselves about all the time, which is the difference between kind of legitimate reuse of non-copyrightable things and illegitimate copyright reuse of things. So I'm going to start with Angelo, who I see in the room.
Yeah, so this is a really interesting question, and it's not a black and white line, right? It's going to be kind of a fuzzy answer. You might get used to that from lawyers. But this does touch on an idea in copyright called the idea-expression dichotomy. You can protect an expression of an idea, but you cannot protect an idea. Like the Candy Crush.
Yeah.
Yeah, right. The Candy Crush idea is like, it's an expression of the idea of matching three things, roughly speaking. So there's lots of games that have that sort of premise, but Candy Crush is one expression of that idea. Other similar things. I mean, even before video games, there's something like there's genres of movies, right, that all share similar elements. There's Westerns. There's, all Westerns are going to have cowboys, saloons, horses, gun duels. you can't protect any one of those elements, but you can protect one specific expression of the Western movie, right? So this is why clones of games can exist, you know, and that's why, frankly, clones of movies can exist, right? Like you're going to get the disaster movies that come out right around the same time that have very similar ideas. You're going to get TV shows that are very similar. Babylon 5 and Deep Space Nine for some of the older sci-fi folks. So you can, you know, what is copyrightable is what is expressed, what is put on a tangible form. So the artwork, the sound, you know, that sort of thing. But you can't copyright the concept, if that makes any sense.
Yeah, it's something that is heavily litigated, and the best litigators in the country are fighting about whether or not certain things are copying and certain things are not. It's gray, it's difficult. Don't copy other people's stuff is a really good way to avoid having that problem. Come up with original stuff as much as you can. I didn't see anyone else hand raised on that, so we'll move on to the next question I have here, which is, how are so many artists selling art based on IP that they don't own? This is, to me, one of the biggest internet entitlement issues, apart from entitled gamers generally, but people really feel, fan bases really feel like they are part of the ownership of the IP. And it's really, really tough for a company to come down on their biggest fans and say, we're not going to let you sell this t-shirt, or we're not going to let you sell this thing on Etsy or something like that. But it's also necessary. And so I want to kind of turn it over to folks in the room who have probably dealt with this. I'll start with Brandon.
Yeah, so there's a fine line between, you know, homage, right, which is generally okay, and infringement, which is not okay. So that fine line is hard to walk, right? If I wear a blue jumpsuit because I like Fallout, probably fine. But if I put a 76 on it and I put it on my stream and I monetize, I'm Fallout 76 Lord, probably that crosses some lines, right? So there's a fine line there, but the reality is that a lot of what you see online on Etsy, at conventions, at that sort of thing, is infringement. And the developers, the publishers could theoretically shut a lot of it down. A lot of it doesn't get shut down, not because it's not infringement, but because those developers or publishers have made either the economic calculus, like Ryan mentioned, that doing that is going to be too difficult and too expensive, or because they've made a different economic calculus, which is that tolerating the infringement actually helps build the fan base. But it's generally not that they're looking at it and going, this is fine, right? They're looking at it and going, we will accept this even though it's not fine.
It's kind of how I think video game companies were dragged into the streaming world originally, kind of unwillingly, and then developed an economy around it when they realized, hey, wait a second, we can actually make this work. Jeannie.
Yeah, I just wanted to say, when it comes to IP infringement, I think smaller indie publishers, developers, creators are probably going to let it go and actually welcome it. Like, hey, this is free publicity. But when you get into the AAA companies or companies like Disney and Nintendo, they are IP sharks. Just a real example, there was a company in Tokyo that will let tourists rent a go-kart, and you would be able to like drive around, cruise around the streets of Tokyo. And they would give you the option, like, hey, if you want to use our go-kart, but also wear one of our costumes, you're welcome to do so. And obviously some of those costumes were Mario, Luigi, you know, Princess Peach. And they just got shut down. Like Nintendo basically destroyed that company, and that company no longer exists. So be careful whose IP you sort of rip off.
Yeah, there are strong enforcers and weaker enforcers for sure, and the lawyers know who they are. Angelo, do you want to add something quick?
Just one real quick point, the distinction between what a company legally can do and what maybe they should do. Brandon touched on this as far as like whether or not they would choose to pursue something that they legally had the option to. And an example with Blizzard was that they were very strongly enforcing their IP rights against, let's say, content creators that were making mature content with some of their game models. So if the thing you're doing with that IP is found to be unsavory or something against the interests of the company that owns it, you're going to be more likely to be enforced against, I think.
I thought we were going to get out of this avoiding talking about all the body parts in games that we avoided in the last thing at PG Connects. I saw Brandon and then Yen.
Yeah, just real quick, even beyond something unsavory, right? If you're streaming yourself cheating or exploiting hacks in the game, that's a good way to get your stream taken down. It's a good way to draw the attention of the publisher, especially if that publisher is Epic.
The other distinction I was thinking is, kind of Angela touched on what must they do versus what they can do. I mean, sometimes, especially with trademarks, there is an obligation under trademark law, U.S. trademark law, that you have to monitor and police your use. And maybe you're already, working with other merchandise who, you've given a license to. And so in those cases, oftentimes, there is an obligation for the company to be looking for this infringement, to be shutting it down in order to maintain their rights or the rights that they've granted to their licensees.
Excellent. Okay, thanks, folks. We got another question here. I believe I've got something like 15 minutes left here or something close to that. So we're going to keep plowing through the questions. If selling games at conventions in multiple states, are there any tax concerns? This has been addressed a little bit in the Discord. I didn't know if we wanted to say other than like, we're not tax lawyers, but yes, when you're selling anything in any jurisdiction, there are tax concerns. And sometimes these, I don't know, sometimes these tax concerns really lie in waiting until you go and get an investor or someone comes to buy your company or a publisher comes to publish your game. And they're like, hey, so what have you been doing about VAT taxes in the UK? And you're like, well, I haven't been doing very much. I'm like, okay, so this money that you're asking us for, like a big chunk of that is going to have to go back to pay all those back taxes because the tax authorities know about us. They don't know about you. So I always find this an interesting one. So I don't know, we answered it in the room, I think, unless anyone wants to unmute themselves and say they want to talk about this one. We'll move on to the next question, which is, what issues do you typically see from the game player side, i.e. dealing with the players, as opposed to corporate issues or IP issues? And I'm going to guess that Matt and Yen probably have something to say. We'll start with Yen and move over to Matt.
Yeah, I'll say, I think a lot of the issues, after GDPR, I think it's a lot about, privacy related, what data do you have on me? The other, I think, oftentimes is a lot about, cheating or accounts being shut down or refunds. So those are kind of, I think, the day-to-day that, I feel like our CS team is the hardest working team ever, and they're always taking care of everything. But I think those two, I'm sure, Matt, maybe you've dealt with other ones, but I think those are typically the player-related issues that we have. And so I guess just to touch upon a little bit what to do, I think, all your player-facing documents, like your EULA, like your privacy policy, any of the policies that you have, I think just try to be as clear as possible so that, the player knows kind of what they should do, who they should go to, what they can or can't do to maybe avoid some of those issues up front.
Yeah, Matt.
Yeah, so two things on that. One, what Yan immediately just said about making things kind of clear to the player. Despite what maybe everyone watching this thinks, there's a giant movement right now for lawyers to make things that face players understandable and in plain English. And so a lot of game developers and publishers are revamping all of their terms of service, privacy policies, and EULAs to be written without the therefores and notwithstanding the foregoing, so people can really understand what it is they're signing up for. Jumping over to the player side of stuff, Jan's absolutely right. So player support, CS issues, hackers, cheaters, are all kind of player side issues that we deal with on legal. And the thing that people have to be careful about is it's a pitfall for the company. And so sometimes there will be people that are hackers and the lawyers have to think, how are we going to respond to this? Are we going to send a really spooky letter? Or are we going to send like a really fun, cool cease and desist because we know it's going to be on Reddit where we put the characters like names into the cease and desist and ask you to like not do something that only a player of the game would know, because it's as much of a legal thing as it is also like no one wants to be a jerk to players, not even the company that makes the game. And so it's about balancing that. The other thing that you have to deal with on the CS side is sometimes people will use kind of like the player side contact with a company as a way to kind of set up some sort of legal claim. So occasionally you'll get a CS ticket that comes in that starts off with someone angry that their skin didn't get refunded, or they think that they should have gotten a different drop from a loot box. And then 3 or 4 support ticket follow-ups in, all of a sudden it seems like someone else is writing the ticket, maybe a lawyer that's trying to get the company to say something because maybe they're going to try and set up a lawsuit on the other end. And so I've definitely been in situations before where you've had to sit down and get all the lawyers in the room and think about how are we going to respond to this, because it seems like someone's really paying attention on the other end.
So interesting, Yen.
Oh, I think, Angela, did you want to jump in before
Just one other thing that I think companies have to deal with anytime the game has any kind of user-generated content ability. All of the things that we talked about before about IP rights come into play again. So suddenly you might have to deal with players wondering, like contacting their CS team, like, hey, why can't I make this Hatsune Miku spray for my car? Like that has, why can't I put this other IP into your game? Why is this being taken down? So that's going to be another thing that I think, even players have to worry about IP.
And I think the other, the same group kind of recently did a panel about content moderation. I think, that has become a larger and larger role in, player-facing issues, is making sure that the player, we're creating a very safe and respectful environment for the players. Player safety, what happens if, player responds, or, player health. I think those are kind of, I think, the gray area. The legal line is a little bit blurred, because for a company, usually you just have very strict legal protections, for your employees. But, really thinking about how to create a good environment and a good player experience for your players. I think that's kind of a new area that a lot of companies are looking in, both tech, legal. And then finally, I guess I want to say the other kind of cool thing about player-facing issues is that oftentimes we get notified of infringement or illegal private servers or unauthorized distribution of certain virtual currencies through our players, because they are the ones that are entrenched in the community. They're the ones that get all the information, and oftentimes we get emails saying, hey, you should look into this, you should look into that. And so I think it's a very interesting kind of symbiotic relationship. Oftentimes it's very helpful, other times it's not so great. And so I think managing that line of how closely you work with your player base and communities, can really make a difference in how you run your business.
Jeannie.
Yeah, I just wanted to piggyback on what Matt was saying about lawyers moving away from 40-page contracts and transitioning into contracts with terms that the average person will actually understand. Because today we've gotten to the point where contracts are so full of legal jargon, are so long, that no one is really reading them and no one is really aware of their rights. And so some of the things that younger attorneys are doing is we're trying to cover all of our bases, condense that 40-page legal jargon contract into something that is really digestible by a 16-year-old. And some of the ways that we can do that are through like data visualization. My firm is thinking about like making an anime like PSA, just trying to, I think that's the challenge of lawyering today, as we can see with the Blizzard and Apple litigation, is how can we get creative with the law to meet the current needs of our generation? And I think that's what's really fun and interesting about being a lawyer in this industry, is because we're combining this really ancient old field with this super hyper fast futuristic field.
Yeah, Brandon.
Yeah, just to add to that, this is a struggle like internally for most lawyers, right? We don't want to write 40-page contracts. We hate it as much as everybody else does, but you want to make sure that your client is protected in everything they need to be protected in. And so sometimes people will see like, oh, Microsoft sent me this agreement, it's only 2 pages long. It's like, well, yeah, Microsoft has a team of lawyers that if something goes wrong in that agreement, they will bury you in the litigation file and you'll give up. But you as an independent developer or a small creator or a fan probably don't have those legal resources, right? If you do, great, but you probably don't. And so if you have a lawyer, they're going to try to protect you. And so if you're not getting a 2 or 3 page agreement, if you're getting something that's a little bit longer, give your lawyer a little bit of credit, a little bit of slack, right?
I think a lot of people confuse simplicity and brevity, and they're not the same thing. It's actually hard to be simple and brief and protect all of your clients' rights. There's a reason why lawyers prefer those complex phrases and big words. It's because they are the simplest, often way to express some of those rights. So we do have to be creative. So we have, I believe, like 5 minutes left on this panel. And I want to do like I don't know, lightning round or something, if that makes sense. So I've got questions that I'm just going to fire off. I will ask someone while I'm asking the question to unmute yourself, and you just got to answer it. Okay, here we go. When publishing a board game and working with a manufacturer, how can you make sure that they don't knock off your game and sell it elsewhere? Can you make sure that they won't knock off your game and sell it elsewhere? Again.
It's always hard. I mean, obviously the contract is probably what you can use to protect yourself, but in the end, it's a piece of paper. In order to enforce that, you have to sue, So I think here it's really carefully pick. So you still need the contract, and to really carefully pick a partner that you trust and feel will do right by you.
All right, next question. Do streamers get or need permission, i.e. do they need it? And if they do need it, do they get it to stream a game? Yen, I believe you answered that live in the room. Generally, there are terms that apply to it, but okay. How much of a game can you show without getting permission, i.e. for game reviews? This is probably a fair use question. I don't see any takers.
I guess, I think fair use is just such a crazy area of the law. There are, if it's truly commentary, etc., there is, but the thing you have to know about fair use is that you're already admitting essentially that this is an infringing use, but I have this defense on why I can use it. So that's why fair use can be very dangerous, because you're already crossing into that line. So I think, look at the EULA. Usually game companies now are very clear about their stance. Either they're like, hey, everyone use our IP, do whatever you want, except don't do X, Y, Z, or, you'll see very clearly that they don't allow it. So I think take a look at the website. Generally, you'll kind of get a sense.
All right, I got one for Matt here. Do you have any advice for aspiring lawyers, professionals hoping to further involvement in the gaming community? Matt, go ahead.
Yes, I'm so into this because for a lot of us here that got into games, there was not a path forward and there were not resources out there, and we were kind of told we had to figure it out on our own. So I love saying this on panels. Resources for you. Brandon is the general counsel of the International Game Developers Association. They have a bunch of different interest groups that you can sign up in. They have local chapters.
And scholarships for GDC.
And yes, scholarships to go to these conferences. When I was in law school, one of the best things I ever did was get one of these scholarships. I got paid to fly to the conference. I got to go. I got to meet a lot of the lawyers in this room. Absolutely incredible. If you are a law student, the Video Game Bar Association and the Esports Bar Association have scholarship writing competitions where you can get money and exposure to lawyers for writing academic papers. And I think, as everyone can say here too, just show up. I mean, when I was in law school, I just showed up to the bars that all the lawyers were drinking at the conferences and talked to them until they were so annoyed. They finally were like, dude, we'll do whatever you want. Just leave us alone. But do it. Absolutely do it. And there are tons of other resources. So hit me up after. I will give you links to everything.
That's super cool. Full disclosure, I think Brandon's, you're probably on the board of IGDM, the board of BGBA. So just conflict disclosure there. But yeah, there's awesome resources for lawyers. Honestly, Matt's not wrong. I've been practicing for 15 years and I kind of just faked it at the beginning because there wasn't a lot of resources. There's now a ton of resources, and it's an amazing time. And you can reach out. We're all on Twitter. I think all of us on this panel are on Twitter. In fact, we are organizing or talking on Twitter. So you'll see our handles in the schedule. You can tweet at us. You can reach out to us. We can help you find people in your school or in your state or in your country that might be doing what you're doing. All right.
Yeah, I just want to really quickly add to that, not to get discouraged if you don't immediately get a job in the industry. Yeah. Get a job, get experience, and keep networking in the industry, because
there's no wasted experience.
Yeah.
An option agreement and a contract and an NDA are the same in any industry. Get your experience first. Absolutely right. Okay. How did how does a big IP have like another IP in it? I'm thinking of examples like Big Hero 6 has Stargate in it, or maybe Ready Player One had a bunch of other people's stuff. Is it just someone being too big to worth suing, or can they use other people's IP without paying? Actually, no, it's a lot of licensing. I'm just gonna answer that real quick. The license agreements to those things are crazy. Like, it's a lot of lawyers, hard work to get those deals done. Can anyone on the panel speak to the AMG Blizzard, which I believe is the Humvee decision in Call of Duty, on how it impacted game developers to try and incorporate existing brands into their game? Matt, Brandon. No, Matt's on mute. Yeah.
Go ahead, Brandon.
I was just going to say, I think that probably it didn't really affect most developers. I think that, it underscored that there is a path through the First Amendment to use some of that stuff, but it also underscored that the expense of getting to that path is a lawsuit from a massive company. So it's probably 6 of one, half a dozen of the other.
Awesome. Okay, so we're now at the end of the panel, I believe. I've got, a couple of seconds left. I want to give everyone just a chance to say a few closing words. I just want to thank everyone for coming out. You guys are awesome. I usually get to see you folks in person. I miss you all. My heart goes out to you folks. Most of you folks are my American friends who I live vicariously in the US through you. Stay healthy and sane during these odd times. So I'm going to turn over to Jeannie.
Never lie to the government. It's going to get you in a worse situation.
Matt.
I mean, echoing exactly what Ryan said, and go to the continuing conversation channel in Discord after if you want to talk to us.
Yeah. Yen.
Yeah, the video game industry is so big. We need so many different types of talent. And especially if you're interested in law, I think lawyers love talking about ourselves, what we do. So don't hesitate to reach out. And if someone doesn't respond to you, move on to the next one.
Angelo.
I say this every time we do one of these panels. Thank you so much for coming and listening to us when you could have been looking at the brand new games that were being released. You came and listened to a bunch of lawyers talk.
Yeah, good for you. Brandon.
Yeah, so normally this is where I would tell you which bar we were going to go to continue the conversation. So I'll just join Matt in saying, I guess, jump over to the Discord and we'll keep talking there. And then also we've got 45 days to get ready to go vote. So do that.
Yeah, thanks. Agreed. Thanks, everybody. And I guess, Christina, we are done with the room. So thanks very much, everyone. Have a good day.